The Washington State Supreme Court has previously adopted the American Bar Association standards for attorney discipline. The standard in this case was, and I quote, "The presumptive sanction for sexual assault is suspension. Moral turpitude is too vague and inconsistent a standard to determine appropriate conduct." So that's what the ABA standards call for. I followed the standards. My colleagues departed from the standards. So when we talk about cases, I hope you have a chance to sit down and read the cases. This is not statistics for me. This is real life human beings coming to court, in this case, with their livelihood on the line. Makes general allegations about the criminal law. Well, I am protective of the rights of the accused. The accused has many rights. That's my job. I'm proud of the way I've done that job. But the statistics, once again, are misleading. 90% of the time, a criminal defendant seeks review by the state Supreme Court, which is in 700 or 800 cases a year. I vote no, and that means an automatic affirmance of the previous conviction. As to the rest, the Supreme Court takes the tough cases, the ones that are genuinely in doubt, and I participate with the other members of the Supreme Court, and I'm in the majority overall about 70% of the time. I do dissent in some cases. I do bring a unique perspective to the court. I do think for myself. You know, General Patton said, when we're all thinking alike, somebody's not thinking. And I think that I have to challenge my colleagues, and I have to challenge the people that read my opinions for something new or something old that they've forgotten. Mr. Chushcoff, or Judge Chushcoff, talks about political viewpoint. I don't know what political viewpoint is involved in finding the three strikes, not legislature, but initiative, the three strikes initiative unconstitutional. I had to consider a case where there was a 27-year-old black man. He stole $300 from an espresso stand, armed with a finger in his pocket, and he was sentenced to life without possibility of parole. The case law in this area says that a cruel punishment is a punishment that is disproportionate to the criminal act. I thought that was disproportionate. I suppose that Judge Chushcoff would say, well, if you throw a gum wrapper on the sidewalk and that's a strike, send him away for life without possibility of parole. And I know the people sometimes in initiatives and sometimes the legislature in the form of statutes gets carried away by the passions of the moment, but it's up to the Supreme Court to make sure the constitutional principles are observed. And I believe that was cruel then. I believe it's cruel now. I've been on the court 15 years. This guy's still in a jail cell. I think he could have been a productive citizen. You know, when guys get a little older, they work this criminal stuff out of them. So I don't believe in cookie-cutter justice. I think that the individual sentence should not only match the crime, but it should match the criminal as well. La Miserable talked about stealing a loaf of bread. The guy got 19 years. That seemed like a horrendous sentence. Well, you do that here in the state of Washington 3 times, pushing the clerk out of the way, you get life without possibility of parole. Judge Chushcoff talked about being an advocate for the rights of the accused. Well, I'm an advocate for the rights of every single citizen in this state. That's what a judge does. The argument doesn't end at the podium where counsel is making their arguments. It's taken back into the conference room. And there's diverse points of view. I have my point of view. It may not always agree with some other points of view, but I think I add something to the court. I make my colleagues think. Sometimes these dissenting opinions I start off with end up in majority opinions, sometimes vice versa. I'm proud of my record.
Cut you off there, Justice, and move on to another question.
May I respond to the accusation that I'm guilty of an outrageous falsehood? It's kind of a it really strikes me.
If I might put in, it seems to be a matter of a fact. What he asserted a figure, the justice says it's not right. It's not a matter of opinion, is it? It's which is it?
Well, here's the difference.
The time frame too.
Beg pardon?
It could be the time frame. You made that decision. You made those statistics based upon a 2-year time frame, I think. Is it just the time frame that's the problem?
That's part of it, Mr. Briggs, but there's another aspect of it too. All cases of discipline involving suspension or disbarment do go to the Supreme Court. However, there's no argument, there's no briefing unless the lawyer appeals. and then it results in a published opinion. I'm looking at the published opinions. Justice Sanders says, well, even the cases where no one has appealed and there's never an argument, there's never an opinion, let's throw those in the mix as well. I don't think that's appropriate, but you're absolutely right about the time period. These cases are on my website. Anyone can go look at them, and if they can find an inaccuracy, fine. And that's my response. Thank you.
Thank you.
If I could chime in here, every year the lawyer discipline attorney for the Bar Association publishes a report. I have the reports for the last couple of years here. I have a list of, for example, in 2009, there were 13 disbarments, 20 suspensions. So Mr. Wiggins talks about attorney discipline cases. On every one of those cases, if I don't recuse, I act on every one of those cases. And there may be an appeal, there may not, but the Supreme Court has the responsibility to act on those cases. And in many of the cases that are not appealed, there are dissenters on the Supreme Court that would like to change the ultimate outcome. Justice Alexander often has a different point of view on some of these cases. Usually I'm with the majority. So it's, and I agree it is a question of fact. And I brought every case for the last couple of years, and this is typical of the way it is. I just didn't have a big enough briefcase for the last 15 years.
All right. Moving on to a different topic. All three of you have sat on the bench, so I'm wondering if you can give me an example of an occasion when you've later second-guessed your decision that you made. Tell us a little bit about when you have later decided you might have been wrong. And we'll go ahead and start with you, Julie.
I'll be happy to start with that. The very first case I heard on appeal was a case involving the corpus delicti doctrine, which is just the Latin phrase for the body of the crime. And to have a criminal conviction, there must be evidence independent of anything that the defendant has said. And I had a case like that, State versus Aten, A-T-E-N. What happened in that case was a woman was babysitting a family's children overnight. The small infant was screaming on and screaming and screaming. The woman, who was a grandmotherly type, put her hand over the baby's mouth to stop the screaming. The baby stopped screaming and went to sleep. The baby was breathing. She set the baby down in the crib, and in the morning the baby was dead. And so the question was this a SIDS death, a sudden infant death syndrome death, or was this a manslaughter case? Did she cause the death? And the only evidence that really supported anything other than a SIDS death was her statement. And I wrestled with this under this ancient doctrine that you have to have evidence independent of the word of the accused. It's a protection against confessions, or extorted confessions, ill-advised confessions. And I ruled that indeed there was not enough evidence here. This was a corpus delicti case. Went to the Supreme Court. I think this was before Justice Sanders was on the court, although I'm not sure. And the court upheld the reversal of the conviction. Now I look back on that, and I don't know whether, there was a lot of controversy over that case, and I've thought about it many times. Well, during the course of this campaign, someone came up to me and said, I was a social worker for the family, and after that death, the mother went off the deep end, descended into alcoholism, and couldn't handle her family. The kids were put out into foster homes, and the siblings were severely traumatized by this. They felt their lives were worthless. And it really impacted me deeply. I'm not sure it was the wrong decision, but I've second-guessed myself many times. And what it suggests to me is that a judge has to look at the whole picture and really has to look at the impact on the victim, the impact on other people surrounding the crime, and it's a difficult case. Now the legislature tried to repair that or change the rule, and the Supreme Court again basically reaffirmed the corpus delicti doctrine, which goes all the way to biblical days. I mean, way back. But again, it's just one that has always kind of gnawed at my at my being as to whether was that right and the consequences of it.
Thank you.